Yes, please.
Yes, if I may just continue. I want to just restate the point because you had a very specific question to me regarding Article 226. I'll just state it in possibly clearer terms. Our stand is that as far as the Enforcement Directorate is concerned, it has no right to sue. Absent a right to sue, it cannot maintain a 32, it cannot maintain a 226, it cannot maintain a 227, it cannot maintain a suit. However, it's not as if there is no remedy in this situation because the Union of India can sue. That comes from Article 300 of the Constitution of India. And there I have made my submission that the usual manner would be under Article 131, but there may be other situations as well. But certainly, since the question is, can Directorate of Enforcement sue under 226 or any other proceeding, our understanding of the law is that it cannot. Now, just before I return, because I have just this morning, the Lordships were good enough to note a large number of provisions. So we've just had that typed out, that table. So I'll just give it to the other side of it. This is already covered, this ground. So it sets out the SEBI section 3.2 and then the pari materia provisions we have, without setting them out, we have indicated them. And the second part, which is table B, is various other prosecutorial and investigating agencies who have no power to sue. And we raise this in the context that if we allow it, then probably it may have to extend to all these, which doesn't appear to be the constitutional scheme. You know this? Yes. The second point, I just have it out of the way, is what is a directorate? Now, there's one useful definition in the context of government, and in Black's Law Dictionary, the second definition is a governmental division. A governmental division. And when you have a governmental division, that's definition 2 of Black, which is on the opposite side, the back, reverse side, towards the bottom of the left-hand column. Office of Director of a Governing Board, we're not concerned, but a governmental division. That's it. That's what it is. It's only a governmental division. And if that is the case, then in our respectful submission, while the central government can sue as Union of India, the Constitution provides for it, it can't be that you have an enforcement directorate which just lands up over it. Now, just for a moment, because I was on part 3, so I'll take you to part 3. But just before that, just have a look at the two writ petitions. So please first take up, there is a Directorate of Enforcement Writ Petition 16.
Yes.
Now here, just have a look. Your Lordship may go after the alphabet pages. There's page 1. Your Lordship has the title page on page 1, so that you have who the parties are. No, sorry, this is Petition 16, 16 of 2026.
Yes.
So here, number 1 is the Directorate of Enforcement, and number 2 is Robin Bansal, so-and-so, currently working as the Deputy Director of the Directorate of Enforcement. And then at the foot of page 2, you will find writ petition under Article 32 of the Constitution of India. So this just now on this particular point, I am on a demurrer. So just have a look directly as to what they state at page 22. What is the basis? They say they're coming under 32. Now let us see the foundation of what they say in this petition regarding 32. Please go to alphabet I think. Part of the grounds. Capital I on page 22. This is Anjaria.
Just 1 minute.
Yes, yes. at all for the purpose. On that, there is another. So this is one. Now you just, please, may I request you to take up writ petition 17, and then I'll come to part 3. 17 of 2026.
Yeah, you come.
Yeah, I don't know. We'll do that after we finish that. Now this is a, sorry. May I request you to turn to page 1 here again. Now, I would respectfully, so just note 2 or 3 things. First, page 1 will have the cost title. I'll just state my point first. This is nothing but a thinly veiled petition, again on behalf of the Enforcement Directorate and nobody else. This is my first respectful submission and assertion. So you have a memo of parties which has 3 individuals who, as your lordships will see from the cost title itself, say that they are various officers of the Enforcement Directorate. Your lordship has that from the cost title itself. But even this thin veil is removed by the petitioners themselves. So please go to page 3, first paragraph, opening paragraph. That the present writ petition is being filed by the Directorate of Enforcement. Please mark that. Filed by the Directorate of Enforcement. Please go to page 5. Paragraph 3. That the petitioners herein, that is the Directorate of Enforcement, initiated an investigation. Have you marked that? Then please go to page 22. Roman 3 on page 22. The ED seeks enforcement of positive obligations upon the state. Roman 3, first line. The Enforcement Directorate seeks enforcement of positive obligations of the state. So I'm just giving you a sample. And please see page 44-45. I'm just giving you a sample of the pleadings. So while someone might say it's thinly veiled, they are fair enough to unveil themselves and reveal that they are nothing but the Enforcement Directorate. This is really an abuse of process according to me. There is, I think, a paragraph which is triple Q. Well, your lordships have that. I have a page number which says page 44-45.
Yes.
And then it says, because a writ petition under Article 32 of the Constitution has been entertained by this Honorable Court in the past at the behest of the Director of Enforcement, wherein the state of Tamil Nadu was doing X or Y or Z. So this is all nothing but a Directorate of Enforcement writ petition, again, but thinly disguised, and then they are gracious enough to unveil themselves, and we now see the real face behind the veil. The face is no one else but the Enforcement Directorate by their own drafting. Now please go back to where I was in the pre-lunch session, which is part 3.
Yes.
Now I was on Article 14. Your lordships have already noted the definition of state in Article 12, which is very important. We'll come to that. But let us look at 14. Now, there are 2-3 features in 14 I want to emphasize. First, equality before law, of course, is the marginal note. Then I'll read it at a go. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So I make 2-3 points. First, it is the state that shall not deny. And it is the state shall not deny qua any person. So the person has to be either a natural person or a juristic person. Article 14 is not available to a directorate which is not a body corporate or a juristic entity. Not available. It has to be a person. Now, This is qua a state on one side and a natural person or a juristic person. So now I'm just digressing for a moment, because this point which I'm now making extends beyond merely Article 14. And the point I'm making is that when you see the scheme of Part 3 of the Constitution, it does not envisage one limb of the state contesting against another limb of the state. You can't, the submission, you cannot, it's not even within the thought process of the framers or the language or the structure or the intent or the purpose. It is citizen, natural person, a person non-citizen but natural person, maybe even a juristic person on one side who is not state on one side. So it could be a corporation, for example, and the state on the other side. So state versus state is completely alien to the most fundamental notion of Part 3 of the Constitution of India. Now, for the purposes of Part 3, the state is one entity. Now, let me just clarify what I mean by that. I accept that as far as the state is concerned, you can have instrumentalities of the state. Of course you can. You can have different elements of the state or different creations or structures within the larger format of state. So you have the state government, you have a state corporation, you have various public sector corporations which your lordships have held are instrumentalities of the state. All of that is permissible, but all of that falls within the broad category and bracket of state. So it's one side state. So here you have a situation where you have the state on two sides in the array of parties which you have seen, which is a concept alien in our understanding of the law to Part 3 of the Constitution. And in any case, I would respectfully submit, as I have earlier, that this is perhaps a situation where it ought to be decided authoritatively by a bench of learned judges, as the Constitution under 145(3) mandates. Now let us look at 15 for a minute. 15 is not invoked, but just to see the structure. Please see. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. The state shall not discriminate against any citizen. 15.1. This is to give you a flavor and a sense of all these particular articles. So 15. Please see, as far as 16 is concerned. 16.1. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. It's not that the state is unitary. The state will have instrumentalities and divisions, but it is on the one side citizens or persons, and on the other side the state. It can't be the state on both sides, as is what our respectful submission. Then you of course have 17, untouchability abolition, and please see thereafter you have option of titles under 18. Now look at 19, protection. This is important. So this is for citizens. 19. All citizens shall have the right. So this is confined to citizens. But then please see, so enumeration, freedom of speech and expression, assemble peaceably and without arms, form associations, move freely throughout the territory of India. Then please see, sub-article 2, which is very important for understanding the content. Nothing in subclauses A or subclause A of clause 1 shall affect the operation of any existing law or prevent the state. So it is citizen qua state. Prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of rights conferred by the said subclause in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offence. And your lordships have authoritatively held again in a constitution bench that these are exhaustive categories. These categories mentioned in 2 are exhaustive. You can't add to them. You can't bring in something new which is not there. So this is again freedoms conferred on the citizen. State has a power to legislate through law, make certain reasonable restrictions, but there is an enumeration. Similarly, nothing in subclause B of the said article shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the sovereignty and integrity of India or public order, reasonable restrictions, or the exercise of right conferred by the said subclause. And you have, in a similar vein, I'm not reading it, but subclause, sub-articles 4, 5, 6 are similarly powers conferred on the state to enact legislation which is reasonable and which is on those subject matters which are enumerated. Now please see then Article 20, protection in respect of conviction of offences. That doesn't apply here. Now look at 21, because 21 is invoked by them. No person shall be deprived of his life or personal liberty except according to the procedure established by law. Now here I respectfully submit that person must be, so I have a twofold submission here, threefold. First, person in the context of protection of life and personal liberty means, according to me, a natural person. That's my first point. It's a natural person. Here person may not, in my respectful submission, cover a juristic entity. That's one. The second is that the Enforcement Directorate is not a person. And the third is, in any case, there is no question of Article 21 coming into place, because there is no question of the life or personal liberty of the Enforcement Directorate being trampled upon or in any manner impeded by action which they complain about. So 21 is completely alien. 14 is alien for the reasons I have briefly indicated. 21 is again, in our respectful submission, has no application, which takes us to 22. 22, Article 22. That's also mentioned in the body of the petition which I read to the court. Protection against arrest and detention in certain cases. Your Lordship has that. No person who is arrested shall be detained in custody without being informed as soon as may be of the ground for such arrest, nor shall he be denied the right to consult and to defend by any legal practitioner of choice. And every person who is arrested or detained in custody shall be produced before the nearest magistrate, etc. And then it goes on. Now here, when you go through the petition, there is not even an averment or an allegation that anybody has been arrested or detained in terms of such as would attract 22. And certainly the Enforcement Directorate cannot be. So Article 22 again does not have any application, is our respectful submission. Now if your Lordship just casts an eye over the other remaining articles in Part 3, please just see 23, prohibition of traffic in human beings and forced labour. 24, no child below the age, prohibition of employment of children in factories, etc. All of this is to the advantage of the citizenry, is to the advantage of individuals, human beings who are the state. Then you have a right of freedom of religion, subject to public order, morality and health, and to other provisions of this part. All persons are equally entitled to freedom of conscience and the right to freely or to process, practice or propagate religion. Nothing in this article shall affect the operation of any existing laws or prevent the state from making any law regulating or restricting any economic, financial, political or other secular activity which may be associated with the religious practice, providing for welfare, social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Then you have freedom to manage religious affairs. Article 27 is freedom as to payment of taxes for promotion of any particular religion. 28 as to the attendance at religious instruction or religious worship in certain educational institutions. 29, protection of interests of minorities. 30, right of minorities to establish and administer educational institutions. Then 31A is the savings of certain particular sets of provisions which your Lordships are aware of, pursuant to directive principles, etc. And then 32, remedies for enforcement of rights conferred by this part. The right to move the Supreme Court by appropriate proceedings for enforcement of the rights conferred by this part is guaranteed. And then your Lordships, I read that earlier part, etc. So I would respectfully submit that having regard to the scope and ambit of Part 3 of the Constitution, for the Enforcement Directorate to even seek to invoke some article or some breach is completely alien to the fabric and the notion, elementary notions in our respectful submission. And it may not be enough to say that that's a respectful submission, that look, we have evolving concepts, etc., and therefore please evolve the Constitution. There has to be some textual and purposive reason for this. There doesn't seem to be. And there's a very good and compelling reason for not allowing this, that we have suggested to the court, that otherwise you will have all sorts of any directorate, any division, without going through the rigor and discipline of a 131 suit, just filing a petition which will create havoc on our, at least in our understanding. So now I just want to mention the point and then I'm coming to a few decisions. The point is that state versus state is nowhere contemplated under Article 32 of the Constitution. So your Lordship shall just keep that. Now the Enforcement Directorate did seek to invoke this parents patriae, etc. And it did approach the Bombay High Court under Article 227 of the Constitution. So the Bombay High Court passed a detailed order. I'm going to comment 2 paragraphs of reasoning in that because I think that might persuade the court. I mean, at least in terms of the constitutional gravity of this case. And so I'll place that reasoning, and I might also indicate that our court here then declined to interfere. So let us just see what the reasoning here is. Your Lordship sees this is a judgment which is rendered. Sorry, you have it? Yeah, I've just handed it over. So it's a judgment of 21st December 2020. Give it to them. It's titled Directorate of Enforcement versus State of Maharashtra and others. Your Lordship has it? Okay. So this is, your Lordship may just note it, it's a division, it's a single judge, 21st December 2020. Now please go directly to paragraph 17. So the pages are at the foot of the page, 19. Your Lordships have it?
Paragraph?
19. Oh, sorry, my mistake, 17.
Yes.
The petitioner ED, your Lordship has that part? I'll just place it.
Yes.
The petitioner ED claims to be an injured, a victim in a representative capacity of the victims. According to the petitioner ED, the ED being a victim of economic offences which are serious in nature, having large repercussions on the economy of the country, would have locus to be heard before the closure report is accepted. According to the petitioner ED, the offence being a crime against society, it is the duty to ensure that the culprits are properly prosecuted. Learned ASG submitted that the petitioner ED would fall in the category of interested person, as the agency, the Enforcement Directorate, is not only entrusted to bring the offenders to book, but is also entrusted with the task of ensuring that money laundering does not take place. He further submitted that the petitioner ED, being intrinsically interested in the outcome of the FIR, is entitled to be heard before the closure report is accepted. Reliance is placed by the learned ASG on observations in certain judgments relied upon, stating that the object and reasons of enacting the PMLA cannot be disputed. However, the judgments relied upon have no bearing on the facts of the case, inasmuch as the said judgments pertain to rejection of bail under PMLA. Having considered the law in this regard, the petitioner ED, by no stretch of imagination, can either be construed to be a victim or an aggrieved, injured, interested person, thus entitling them to be heard before a magistrate decides whether the closure report ought to be accepted or not. The respondent number 1, State of Maharashtra, is an investigating agency in the present case who has filed a closure report in a case instituted by the respondent number 2, Akbar Travels. The petitioner ED is not a supervisory authority over the respondent number 1 state who has investigated the case. Take a hypothetical example, a converse situation. If in a given case, any other investigating agency feels that the Enforcement Directorate has not investigated the case properly, can the said investigating agency intervene in the investigation being carried out by the Enforcement Directorate? Can they be permitted to do so? The obvious answer is no. Each investigating agency is expected to investigate the case before it, fairly on the basis of the material gathered by them during the investigation, and thereafter submit its report. No investigating agency can claim supervisory jurisdiction over the other in a matter of investigation. In the present case, the magistrate is yet to pass an order on the closure report. It is for the magistrate, after hearing the parties, to consider whether to accept the closure report or not, or to direct further investigation to issue process. The respondent number 2 complainant is contesting the closure report for filing the protest petition. Petitioner ED is an independent investigating agency empowered to investigate under PMLA and FEMA, and in the facts cannot be termed as a victim of aggrieved, injured, interested person having regard to the judicial pronouncements. There is no provision in law which supports the claim of the petitioner ED with respect to its locus to intervene and contest the closure report. Thus, the petitioner cannot be permitted to intervene and contest the closure report filed by the respondent number 1 state. Now, this came up, and that's the short order, I believe, which is also handed over. Yes. On 26 September 2022, having heard so-and-so for the respondent, so-and-so, keeping in view facts, circumstances of the case under which the impugned order came to be passed, we see no reason to interfere. Question of law, if any, raised, is kept open. Needless to mention that the petitioner has any other rights and remedies, they may avail the same. So the Directorate of Enforcement itself had come up and it was felt that this is not an appropriate case for intervention, for interference under Article 136. Now, my lords, the issue on Article 32 and the necessity that there is required to be a breach of violation of fundamental rights, and failing that, no 32 lies, is also the subject of several judgments of your lordships. I'm starting with the Constitution Bench judgment in Ramdas Athavale versus Union of India, 2010, for SCC, page 1. Yeah. Yes, this is the one. You already have it. The second last. Your lordships have that judgment.
Yes.
May I indicate the appropriate paragraph? According to us, there are 46 and 47, which are right towards the end.
46?
Yes, right at the end. Last page.
Yes.
So this is the court speaking through Justice B. Sudarshan Reddy. It is equally well settled that Article 32 of the Constitution guarantees the right to a constitutional remedy and relates only to the enforcement of the right conferred under Part 3 of the Constitution. And unless a question of enforcement of fundamental rights arises, Article 32 does not apply. It is well settled that no petition under Article 32 is maintainable unless it is shown that the petitioner has some fundamental right. Now, may I pause here for a moment? The Enforcement Directorate has no fundamental right. In Northern Corporation Union of India, this court has made a pertinent observation that when a person complains and claims that there is a violation of law, it does not automatically involve breach of fundamental right, for the enforcement of which alone Article 32 is attractive. We have carefully scanned through the averments and allegations made in the writ petition and found that there is not even a whisper of any infringement of any fundamental right guaranteed by Part 3 of the Constitution. We reiterate the principle that whenever a person complains and claims that there is a violation of any provision of law or constitutional provision, it does not automatically involve a breach of fundamental right, for the enforcement of which alone 32 of the Constitution is attracted. It is not possible to accept that an allegation of breach of law or a constitutional provision is an action in breach of a fundamental right. The writ petitions deserve dismissal. So here, of course, according to us, they fail. The petition fails on a demurrer on both counts. First, you're not a person who has any fundamental rights. And secondly, apart from locus, which is the point which we are canvassing, there's no question of you being the state complaining about some other organ of the state violating your fundamental rights. State versus state is not within Part 3 of the Constitution at all. Now, this has been, of course, followed by the dozens of judgments. So I'll just give your lordship one other, which is 2016. 2 SEC, page 315. So, may I just give you the paragraphs first and then place them? Sorry. Oh. Yeah. May I just give you the paragraphs which I am relying on? Because they are paras 17, 19, 21, and 27. So 17 is at page 321. I'm just on this one issue, the 32 fundamental rights has to be breached. Let me quickly add, the Union of India, if it sues in its name, may in certain situations be entitled to invoke the parents' pathway. So it may be. I'm not saying it can be done. I don't believe it can be done under 32. But there may be a suit which parents' pathway jurisdiction which they file on an action. Also because in Bhopal, for example, they invoke that particular doctrine on behalf of the victims, etc., where you can't. So there may be situations. But I don't believe Union or the Union of India can at all file as parents' pathway in terms directly under 32. That's my respectful submission. But in any case, even assuming it is the Union of India which has to so file. It can't be a Directorate of Enforcement. Otherwise, every division and department will say that I am looking after the interest, parents' pathway, and here I am in court, ready and willing to assist the court. I don't believe that's permissible. Now let's see para 17. From a reading of Article 32, it is manifest that under subclause 1.1 of Article 32 guarantees the right to move the Supreme Court for an appropriate writ for the purpose of enforcing the fundamental rights included in Part 3 of the Constitution. The sole object of Article 32 is the enforcement of fundamental rights guaranteed by the Constitution. It follows that no question other than relating to the fundamental rights will be determined in a proceeding under Article 32 of the Constitution. The difference between the Article 32 and 226 of the Constitution is that while an application under Article 32 lies only for the enforcement of fundamental rights, the High Court under Article 226 has a wider power to exercise its jurisdiction not only for the enforcement of fundamental rights, but also for ordinary legal rights. It is equally well settled that the court under Article 32 will not interfere with the administrative order where the constitutionality of a statute or order made thereunder is not challenged on the ground of contravention of fundamental rights. At the same time, if the validity of the provisions of a statute is challenged on the ground other than the contravention of fundamental rights, this court will not entertain the challenge in a proceeding under Article 32 of the Constitution. Northern Corporation versus Union of India. A petition under Article 32 of the Constitution was moved by the transferee licensee holder. The maintainability of the application under 32 of the Constitution was seriously objected by the Union of India. Writing the judgment, the Honorable Sabyasachi Mukherjee, the then Chief Justice, held. However, there is a far more serious objection in entertaining an application under 32 of the Constitution. Article 32 of the Constitution guarantees the right to move the Supreme Court for enforcement of fundamental rights. If there's a breach of a fundamental right, the petitioner can certainly have recourse to 32 of the Constitution, provided other conditions are satisfied. But we must, in all such cases, be circumventive of what is the right claim. In this case, the petitioner, as such, has no fundamental right to clear the goods imported except in due process of law. Now, in the facts of this case, such clearance can only be made on payment of duty enjoined by the Customs Act. In a particular situation where customs duty is payable at the rate prevalent, or a particular rate on a particular date or not, has to be determined within the four corners of the Customs Act 62. The petitioner has no fundamental right as such to clear any goods imported without payment of duties in accordance with law. There is procedure provided by law for determination of the payment of customs duty. The revenue has proceeded on that basis. The petitioner contends that duty of a particular rate prevalent at a particular date was not payable. The petitioner cannot seek to remove the goods without payment at that rate or without having the matter determined by the procedure envisaged and enjoined by the law for that determination. The petitioner, without seeking to take any relief within the procedure envisaged under the Act, has moved the court for breach of a fundamental right. This is not permissible and should never be entertained. In a matter of this nature, where the liability of a citizen to pay a particular duty depends upon the interpretation of law and determination of facts and the provision of a particular statute for which the elaborate procedure is circumscribed, it cannot conceivably be contended that enforcing those provisions of the Act would breach fundamental rights which entitle a citizen to seek recourse to Article 32 of the Constitution. We are therefore clearly of the opinion that relief under 32 is wholly inappropriate in the facts and circumstances of the present case. And then they go on for the procedure, etc. Now just have a look at paragraph 21 as well, which makes reference to another judgment. In Ram Javaya Kapoor versus State of Punjab, the petitioner was carrying on the business of printing, publishing books in the sale of including textbooks and in schools in the state of Punjab. The state of Punjab decided in furtherance of the policy of nationalization of textbooks for the school students. According to the policy, all the recognized schools had to follow the course approved by the course of studies approved by the government. The petitioners alleged in support of their petition under Article 32 that the Punjab government had, in pursuance of their policy of nationalization of textbooks, issued a series of notifications regarding the printing, publication and sale of these books and thereby ousted them from their business altogether. Dismissing the writ petition, a 5-judge constitution bench headed by the then Chief Justice observed, as in our view, the petitioner have no fundamental right in the present case, which can be said to have been infringed by the action of the government, the petition is bound to fail on that ground. This being the position, the other 2 points raised by Mr. Pathak do not require consideration. All the petitioners, as the petitioners have no fundamental right under 19(1)(g) of the Constitution, the question whether the government could establish a monopoly without any legislation under 19(6) of the Constitution is altogether immaterial. And then it goes on to further elaborate. And then, finally, your Lordship may just see para 27. Under Article 32 of the Constitution, this court is not supposed to go into finding of facts recorded by the authorities and to come to a different conclusion. Moreover, having regard to the law settled by the Constitution bench of this court, in a number of decisions, in our considered opinion, the right so claimed by the petitioners are not fundamental rights, and hence the same cannot be agitated directly before this court under 32 of the Constitution. Now, the next decision which I wish to place is a recent judgment in the presidential reference. Now here, Your Lordships have Your Lordship saw the title, right? In assent without assent holding or reservation of bills by the Governor and the President of India. Now, my Lords, the entire presidential in the first paragraph, as is customary, resolved disputes between the Union Government and the state governments, except by way of a suit under Article 131 of the Constitution. So this was an express question, which was framed, which I think comes up in our present case, though it can take different forms. Now, what our court did, which is entirely within the prerogative of our court, is that it can return the reference on certain aspects without answering them. The Lordship will find that in paragraph last page, 165.14. Last page. Question 14, Your Lordship has that?
Yes.
Pertaining to the court's jurisdiction to resolve disputes between the union and state governments outside Article 131 is also found to be irrelevant to the functional nature of the reference and hence returned unanswered. Returned unanswered. But I thought we should point this out because this is really something which the President also sought some assistance of the Supreme Court, but our court felt that in the facts and circumstances it may not be necessary at that stage. Now the question arises under 145.3, which I have placed this morning. Now, just for some guidance on this principle under Article 145.3, I would like to first take your Lordships to in Pradeep Chandra Parija, which is 2002 1 SCC page 1. Our Constitution bench has explained the mechanics. So your Lordship recalls the question is also, our court has also laid down that a bench of 2 learned judges cannot directly elevate the matter unless there's a conflict, etc. of 3. But insofar as 145.3 is concerned, that is exceptional. If a bench of 2 learned judges are satisfied that there is a question on the interpretation of this Constitution itself which is involved, then 2 can elevate it in the sense, request the Chief Justice of India and frame the questions, etc. and request the Chief Justice to proceed. Now, if, your Lordship may just see paragraph 2, may I read paragraph 2? Paragraph 2.
Yes.
The question is whether 2 learned judges of this court can disagree with the judgment of 3 learned judges of this court, and whether for that reason they can refer the matter before them directly to a bench of 5 judges. Your Lordship, that was what they were considering.
Yes.
We may point out at the outset that in Bharat Petroleum, a bench of 5 judges considered a somewhat similar question. 2 learned judges in that case doubted the correctness of the scope attributed to a certain provision in an earlier Constitution bench judgment and accordingly referred the matter before them directly to a Constitution bench. The Constitution bench that then heard the matter took the view that the decision of the Constitution bench binds a bench of 2 learned judges and that judicial discipline obliges them to follow it regardless of their doubts about its correctness. At the most, the bench of 2 learned judges could have ordered the matter to be heard by a bench of 3 learned judges. Learned counsel for the appellants drew our attention to the provisions of Article 145, clauses 2 and 3 of the Constitution of India. Clause 2 empowers the making of rules to fix the minimum number of judges of this court to sit for any purpose. Clause 3 says that the minimum number of judges who are to sit for the purposes of deciding any case involving any substantial question of law as to the interpretation of the Constitution or for the purpose of hearing any reference under Article 143 shall be 5. Learned Counsel drew our attention to Order 7, Rules 1 and 2 of the Supreme Court, Rule 66. Rule 1 says that every cause, appeal or matter shall be heard by a bench consisting of not less than 2 judges nominated by the Chief Justice. Clause 2 says that where in the course of a hearing of any cause, appeal or proceeding, a bench considers that the matter should be dealt with by a larger bench, it shall refer the matter to the Chief Justice, who shall thereupon constitute such a bench for hearing. Learned Counsel submitted that the bench of 2 learned judges that made the reference in this case did not overrule the judgment of 3 learned judges in the case of Nityanand Kar, and they should, as they could have, on the basis of an earlier Constitution Bench judgment, which incidentally is not even mentioned in the referral order, but had chosen to refer it to the Chief Justice who had constituted a Constitution Bench. In learned counsel's submission, the circumstances would arise where it would be permissible for a bench of two learned judges directly to make a reference to a Constitution Bench. For example, when two judgments of a Constitution Bench were in conflict with each other, or a judgment of three judge bench was per incuriam. In learned counsel's submission, the present was a case which justified reference directly to a Constitution Bench. The learned Attorney General submitted that a Constitution Bench judgment of this court was binding on smaller benches, and a judgment of three learned judges was binding on bench of two learned judges, a proposition that learned counsel for the appellants did not dispute. The learned Attorney General drew our attention to the judgment of the Constitution Bench in Subcommittee of Judicial Accountability versus Union of India, where it has been said that no coordinate bench of the court can even comment upon, let alone sit in judgment over, the discretion exercised or judgment rendered in a cause in a matter by another coordinate bench. The learned Attorney General submitted that the appropriate course for the bench of two learned judges to have adopted, if it felt strongly that the judgment in Nityanand was incorrect, was to make a reference to a bench of three learned judges. The bench of three learned judges, if it also took the same view of Nityanand could have referred the matter to five learned judges. In the present case, the bench of two learned judges has in terms doubted... Para 7 is important for us, Manoj. The last line. The only situation where two learned bench may refer a matter directly to the Constitution Bench is when the provisions of Clause 3 of Article 145 are attractive, which I believe is the case over here. So that is why this... Yes. And then that other one. This is yes. Now, you may just note the citation of 2005 to SCC 673, which is also a Constitution Bench in Central Board of Dawoodi Bora, also a five-judge bench. And here, Manoj, I'm just inviting attention because they refer to and approve. I mean, they were bound by it. But paragraph 5 is relevant. I'll just read that statement. In Bharat Petroleum Corporation case, the Constitution Bench has ruled the decision of two learned judges of this court binds the bench of two learned judges. At the most, they could have ordered that the matter be heard by a bench of three learned judges. Following this view of law, what has been declared by this court in Pradeep Chandra Parija clinches the issue, which is what I had mentioned, that that's the situation where two learned judges can indeed refer it. Have you given me that? Yeah. Now, my lords, I am just going to place before you the 9-judge bench judgment of S.R. Omai. May I just give you the para numbers, because there's a plurality of opinions over here.
Yes, yes.
So can I just state the point? I think it's well settled, but you never know these days. So the federalism is part of the basic structure of the Constitution. And decisions like the present one will reverberate right through our entire federal structure. If you are going to go to one department to raise Article 32 petitions or 226 petitions, who is not a person with no right to sue. So it has huge reverberations which will go right through. So I will, with your permission, give you the paragraph numbers where learned judges have held that in the basic structure, constellation of rights or features which are protected, federalism is one of them. So you can't make India, as I understand it, into a unitary, non-federal, for example, nation. So here, look, I'll just give you the paragraphs. So there's paragraphs 96. What is this? At 106. This feature. The Lordship can just give me a moment. Yeah. So para 106 verse.
Yes. Yeah.
Whereas paragraph 106 of the judgment at page 118, the federal principle, social pluralism and a pluralist democracy, which form the basic structure of our constitution, demand the judicial review of the proclamation, etc. That was Justice Sawant speaking in para 106, speaking for himself, and Justice Kuldeep Singh. Then your lordships may just go directly to paragraph 247, which are the conclusions in Justice K. Ramaswamy's judgment. The state, qua the constitution, is federal in structure and independent in its exercise of legislative and executive power. However, being a creature of the constitution, the state has no right to secede or claim sovereignty. Qua the union, the state is quasi-federal. Both are coordinating institutions and ought to exercise their respective power, adjustment, understanding, accommodation to render socio-economic and
Reading
political.
from 247.
I'm reading, yes. Because that's the first line. Federalism envisaged in the Constitution is a basic feature. Your Lordship has that. So 247, and then Your Lordship will just see paragraph 276 in Justice Jeevan Reddy's judgment.
76.
270, paragraph 276.
Yes.
Who supports the majority. The fact that under the scheme of the Constitution, great power is conferred on the centre vis-a-vis the states does not mean that the states are mere appendages. Within the sphere allotted to them, states are supreme. The centre cannot tamper with powers. More particularly, the courts should not adopt an approach, an interpretation, which has the effect, or which tends to have the effect of whittling down the powers reserved to the states. It's a matter of common knowledge that over the last several decades, trends world over towards strengthening the central governments, be it a result of advances in technology, scientific fields, or otherwise. And that even in the USA, the center has become far more powerful, notwithstanding the obvious bias in that constitution in favor of the states. All this power puts the court on guard against the conscious whittling down of the power of the states. Let it be said that the federalism in the Indian constitution is not a matter of administrative convenience, but one of the principles, the outcome of our own historical process and a recognition of ground realities. This aspect has been dealt with elaborately by Sri M.C. Setalwat in the Tagore Law Lectures, Union and State Relations under the Indian Constitution. The nature of Indian federalism with reference to its historical background, the distribution of legislative powers, financial and administrative relations, powers of taxation, provisions relating to trade, commerce and industry have all been dealt with analytically. It is not possible, nor is it necessary for the present purposes to refer to them. It is enough to note that the Constitution has certainly a bias towards the centre. It's equally necessary to emphasize that the courts should be careful not to upset the delicately crafted constitutional scheme by a process of interpretation. So I commend this, my lords, the wisdom of this judgment to your lordships as well, that there's a very delicately crafted scheme over here, and having regard to that, given the remedies, etc., it may not be appropriate for the for entertaining these particular petitions. Now, the Enforcement Directorate, this is not the first time that it made an effort to petition your lordships. It did so in the past as well. And here I wish to just place two writ petition orders. I mean, they're not certainly binding, but it just is probably gives you a hint about what might happened in those cases. So this is you have it? The first is an order of 9th February 2024. It's a very short order where the Directorate of Enforcement had come up in 32 against the state of Chhattisgarh. And on 9th February 2024, in their wisdom, they decided to withdraw the petition. So that's the first order. The Lordship sees on top, writ petition criminal. The second order is more recent. It is 8th of April 2025. This is again writ petition criminal. The title is again Directorate of Enforcement versus State of Chhattisgarh. Learned Additional Solicitor General seeks permission to withdraw the writ petition under 32, and the same is disposed of as withdrawn. Learned Additional Solicitor states that he is relying on an affidavit so and so, therefore the file of this disposed writ petition shall be kept along with SLP, and gets tagged with an SLP. So at least this is what we were able to show with respect to our research. So this is a preliminary point which I believe merits consideration by the Supreme Court. Yes.
You said these two orders should be shown to them rather to the court.
Shown to them? No, all I'm saying is it's, I mean,
Precedential value of withdrawal.
it has no precedential value. It has absolutely no precedential value.
Shown to them means if they become wiser and do the same.
Now, wisdom is not anybody's. It's not for me to suggest that. But in our respectful submission, there's also, I might just mention that I'll just give you the citation. In Keshavananda Bharti as well, there is a observation with regard to federal structure being part of the basic structure. This is in the judgment of Justice Shelat and Grover. Now, I'll give you the citation and the paragraph number. So 73 for SCC 225. We have, just that relevant extract is being given. 1973, volume 4 SEC, page 225. So Justice Shelat and Grover were part of the majority. Last line in para 486 on page 408. The Constitution has all the essential elements of federal structure, as was the case in the Government of India Act 1935, the essence of federalism being distribution of power between the Federation of the Union.
486 you are reading?
Yes, last line on page 408, in 486, you are right.
Last line in 408 or 409?
On page 408.
Yes. The Constitution has all essential elements.
Yes, of a federal structure. And distribution. And then it goes on to elaborate the federal feature, etc. of the Constitution. So, I would respectfully submit that in our understanding of the law, this is really a very an issue which sort of bristles with dimensions, and a very profound and deep issue which has ramifications, as I have indicated. It's perhaps an appropriate case to be decided authoritatively by a bench of 5 learned judges. I'm very grateful. Thank you.
Yeah, sure. After my learned friends, Maharaj, the detailed, exhaustive, and learned presentation, Maharaj, I'll try and add a bit of my wisdom if I have left any, Maharaj. But on his wisdom, Maharaj, we'd rather rely on your wisdom than theirs.
No, it is the collective wisdom of all.
Now, Maharaj, let's briefly, Maharaj, what my submission is going to be, and it's going to be, I'm not going to repeat anything that my learned friend has said. Well, what is PMLA? PMLA is a statute which empowers certain officers who are authorized under the statute to investigate. That's the PMLA. Nothing more than that. So every officer so authorized is empowered statutorily to investigate an offense. This is true, Maharaj, of all investigating agencies which are authorized to investigate under the statute. It is true of the code. It is true of CBI. It is true, Maharaj, under the Drugs Act, NDPS. So there's an authorization by the statute. So fundamentally, there can't be a fundamental right in these officers. No officer has the fundamental right to investigate. Right? I start with that proposition. Now, let's look at the statute so that we know, what the extent of rights are. Kindly have a look, first of all, at the definition. Section 2. Clause D small a.
Section
2. Clause D small a.
Yes.
Authorized person means an authorized person as defined in clause C of section 2 of FEMA, which my learned friend pointed out at the beginning. Then kindly come to, before that, 2 small c, assistant director. Means an assistant director appointed under subsection 1 of section 49.
Yes.
Then kindly come to 2 small j. Definition of deputy director. Means a deputy director appointed under subsection 1 of section 49. Then come to the definition of director, 2 small k.
Yes.
Director or additional director or joint director means a director or additional director or joint director, as the case may be, appointed under subsection 1 of section 49. Right, Buzz?
Yes.
Now can we straight away come to section 40, and I'll come back. The PMLA is not an authority under the Act.
Yes.
PMLA is no locus as far as this Act is concerned.
Yeah.
There shall be the following classes of authorities for the purposes of this Act. What are those? Director, additional director or joint director, with reference to 2K. Deputy director, right, Mullins? With reference to 2J. Assistant director with reference to 2C. And such other classes of officers as may be appointed for the purposes of this Act. So they are investigating officers. An investigating officer has a right under the statute to investigate. He has no fundamental rights. Now, what is he to investigate? Kindly come to 2 small NA.
Yes.
Investigation, I'm sorry. Investigation includes all the proceedings under this Act conducted by the director or an authority authorized by the central government under this Act for what? For the collection of evidence. So that authority authorized, well, you go back to 49, as I indicated to your lordships first. So that's the investigation to be done under this Act. Right? Now kindly come to 2 small s. Definition of person. Person includes an individual. And the reason why it is defined is because they want to subscribe the powers of the director, deputy director, assistant director to entities defined in S. You can investigate a person, an individual, an HUF, a company, a firm, and an association of persons or a body of individuals, whether incorporated or not, societies, right? Whether incorporated or not. Then let us kindly come to the definition of 2U, proceeds of crime.
Yes.
Proceeds of crime means any property derived or obtained directly or indirectly by any person. That's the definition of person I just gave to your lordships in 2S. So if a body corporate, an individual, or any of those persons, HUF, derives or obtained derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Not any offense. Scheduled offense. Or the value of such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. So they are entitled to investigate proceeds of crime in respect of a scheduled offense. And your lordships will see the scheduled offense is set out in the schedule itself. Right? There are any number of offenses that are set out. We won't go into that for the moment. Then property. Property means any property or assets of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and includes deeds and instruments evidencing title to or interest in such property, assets of whatever nature. And then the offense is defined in 3. Right? So, I just read it. Whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with proceeds of crime. Proceeds of crime must relate to a predicate offense, a scheduled offense. If there is no scheduled offense, there will be no proceeds of crime, right? Including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property shall be guilty of the offense of money laundering, then an explanation is added, and the word or and the word and is changed to or. If you see, look at the definition. In the main part, it is claiming it an undated property shall be guilty of offence of money laundering. And then, kindly see the explanation. It says, for the removal of doubts, it's hereby clarified that the person shall be guilty of money laundering if any person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected to the proceeds of crime, namely concealment, the same word as in the main section, possession, acquisition or use, and projecting. Instead of and projecting, it says or claiming as tainted property. Or projecting instead of and projecting. So they changed the explanation, doesn't matter. We're not concerned with it. We're not concerned with that. Now let's kindly come to section 16. Now 16 is the power to issue summons. Or assist you with the power to have a survey. Notwithstanding anything contained in any other provision of this act.
60 is attachment.
16.
116.
16.
Yes.
Power of survey. Notwithstanding anything contained in any other provisions of this act, where an authority, and that authority is defined, director, deputy director, assistant director, and all others authorized for us. On the basis of material in its possession has reason to believe, the reason for such belief to be recorded in writing that an offence under 3 has been committed, he may enter the place. So what is the power of survey? That's not a fundamental right, that's a statutory right. Right? Because he's entitled to do that. No issue on that. But then there is no, we're ad item on that. We're not questioning the power of the authorized person to come and do what they have to do in terms of the statute. The question is, they have no fundamental right. That's the issue with us, because this is a 32 moved under 32. Then search and seizure. Again, where the director, section 17, where a director or any other officer not below the rank of deputy director authorized by him for the purposes of this section on the basis of information in his possession has reason to believe, the reason for such belief to be recorded in writing, that any person, that person is 2S, which I read to your lordships, then they can actually search and seize. Again, regulated by law, regulated by the statute, right? And whereas to this extent, it is different from the Code of Criminal Procedure, because the nature of search and seizure under the code is somewhat different. Now, let's finally come to, then they can retain the property, we're not concerned with it. Then let's kindly come to section, then 48 I have read to your lordships. Then kindly come to section 50, section 49. I read 48 to your lordship, now 49. So, the central government may appoint such persons as it thinks fit to be authorities for the purposes of this act. So the power is with the central government to appoint persons under the statute to carry out the purposes of the statute. And to that extent, it's a regulatory statute as well as an investigative statute. Then section 50. The director shall, for the purposes of section 13, have the same powers that are vested in a civil court under the code while trying a suit in respect to the following matters. Again, power of discovery, enforcement, enforcing the attendance of persons, including officers, of a reporting authority. The reporting authority here are banking authorities. We're not concerned with that. Compelling production of records, receiving evidence or affidavits, issuing commissions for examination. So your lordships will notice that the entire petition contains that this is the officers who went there under the statute and they wanted some documents. They wanted the production of some documents. Those documents were taken away. That's the tenor. But that's nothing to do with the fundamental right. I don't know how the fundamental right comes into the picture. Where none of these authorities which have these powers under the statute have a fundamental right for this. They have only statutory rights. Now, let's kindly see further. Then, subsection 2. The director, additional director, joint director, deputy director, or assistant director shall have power to summon any person whose attendance he considers necessary whether to give evidence or to produce any records during the course of an investigation or proceeding under this Act. Now, my lords, your lordships put the question to us. If somebody obstructs such a proceeding, what are the remedies? There are remedies available under the BNS itself. There are remedies available under the law, my lords. The remedy is not a writ petition under 32. Because what are you trying to enforce? Not anybody's fundamental right. These are statutory powers given under the statute, my lords, and it's regulated. Their powers are regulated. Now see further. So give it. All the persons so summoned shall be bound to attend in person or through authorized agents, as such officer may direct, and shall be bound to state the truth upon such subject, any subject respecting which they are examined, or make statements, and produce such documents as may be required. Every proceeding under subsection 2 and 3 shall be deemed to be a judicial proceeding within the meaning of 193 and 228 of the Penal Code, and subject to any rules in this behalf by the central government. Any officer referred to in subsection 2 may impound or retain in his custody for such period as he thinks fit any record produced before him in any proceedings under this Act. Then let us kindly come to jurisdiction of authorities is 51. The authorities shall exercise all or any of the powers and perform all or any of the functions conferred on or assigned as the case may be to such authorities by or under this Act. There is no power outside this Act, my lords. So which is the fundamental right that they are claiming? Forget about, my lords, the larger issue of 131 and the central government and this doesn't have any corporate personality. Forget that. Under the statute itself, none of these authorized persons have a fundamental right. And if they don't have a fundamental right, certainly the Enforcement Directorate doesn't have a fundamental right. The Enforcement Directorate, my lords, as a central government appointed these officers. Now, see further. So I was reading, the authority shall exercise all or any of the powers and perform all or any of the functions conferred on or assigned as the case may be to such authorities by or under this Act, or the rules framed thereunder in accordance with such directions as the central government may issue for the exercise of powers and performance of functions by all or any of the authorities. Now, the issuing of the directions or orders referred to in subsection 1, the central government may have regard to any or more of the following: territorial area, classes of persons, classes of cases, and any other criteria specified by the central government. That's also under the Act. The power of the central government to issue directions. The central government may from time to time issue such directions, instructions, and directions to the authorities as it may deem fit for the proper administration of this Act, and such authorities and all such persons employed in execution of this Act shall observe the follow such orders, instructions, and directions of the central government, provided that no such orders, instructions, or directions shall be issued so as to require any authority to decide a particular case in a particular manner or interfere with the discretion of the adjudicating authority in exercise of its. And then 53, the central government may by a special or general empower an officer not below the rank of director of the central government or the state government to act as an authority under this Act. Even a state government authority can be so authorized by the central government to act under this Act. And then certain officers to assist with the officers of custom, that's 54. And thereafter, you have 63. Punishment for false information or failure to give information. So if somebody fails to give information, there is a punitive section. Any person willfully and maliciously giving false information or so causing an arrest or a search to be made under this Act shall on conviction be liable for imprisonment, which for a term which may extend to 2 years, or with fine which may extend to 50,000 rupees or both. And if a person legally bound to state the truth of any matter relating to an offence under 3 refuses to answer any question put to him by an authority in the exercise of its powers under this Act, or refuses to sign a statement by him made in the course of any proceeding which an authority is legally required to sign, to whom a summons is issued under 50, either to attend or give evidence or produce books of account or other documents at a certain place and time, omits to attend and produce books of account or documents, he shall pay by way of penalty, and if he doesn't follow it, then a prosecution will be launched against him under subsection 4. 174 is the section. So the scheme of the Act is that this only, it's a regulatory statute with investigative powers, by authorized persons whose powers are, the contours of whose powers are controlled by the statute. It's like saying, well, that's election law, nobody has a fundamental right to fight an election. These are all statutory rights. So, the first question that you're watching,
Fundamental right is to fight outside.
that also we have no fundamental right. We have a fundamental right, to keep peace. Anyway, that's our duty. So, the schedule that your lordships will see is that page 51. Offenses. This is, unless there's a predicate offense, this ED doesn't come into the picture at all. What does that mean, Millers? First, an FIR is to be filed. Then the ED comes into the picture. Otherwise, ED doesn't come into the picture. Now, there's no FIR. In this case, right? They have come under 32. Under what provision of law have they come under 32? Neither the statute allows it, nor the Constitution allows it, nor Part 3 allows it. But the purpose, their purpose is not that at all. What they are claiming in the petition is, please ask the CBI to investigate this. But the ED can't ask that. ED can't ask the CBI to investigate Bullets.
No, it is not the offense under PMLA which the CBI will inquire.
Of course they are inquiring. They went there only for that.
You must consider and keep in mind that everything is in relation to that incident.
I'm coming to that.
But I'm making it clear, we are not asking that CBI should investigate PMLA offense.
It's not that
The offense is committed by the Honorable
PMLA offense. Did I
Minister
say
and others.
PMLA offense? Did I say PMLA offense? A scheduled offense.
it is.
You are
Not even scheduled offense. Yeah, anyway, we will.
Let's just hold on.
None of these.
Unless there is a predicate offense, the ED doesn't come into the picture. The ED does.
It is quite this particular incident of the chief minister.
Where's the scheduled offense? Where's the scheduled offense?
It is not about scheduled offense.
Then what is?
It is the offense. These are 4 offences which you have registered against them. Yes.
That's a different.
No, that is the only thing. What they have come.
No. For the petition, I'm sorry. Then obviously, your lordships have not seen the prayer in the petition. Not that at all.
Let us read again together. Yes.
Of course.
It is not for any offence under PMLA which they have come here.
PMLA, brothers. Not PMLA.
Yes.
Not
And you are
PMLA.
showing the entire PMLA Act and the scheme of the Act.
The scheme of the Act meaning that they have no fundamental right to invest. They have no fundamental right to invest. But let's see the petition. It's better.
Yes. So what we have understood is,
Yes.
on a reading of the petition is that
Yes.
the officers of the ED are claiming fundamental right where their safety while investigating the offence.
Yeah.
That is only an incident of investigating an offence. But their main plea is that while investigating the offence under PMLA,
Yes.
they have been threatened.
Correct.
They have been threatened.
Correct.
And they have committed the offense intimidating.
Sir, allow me. What's the fundamental right there? They're assuming they have been threatened. What's their fundamental right?
So that they will answer.
I'm sorry. No, I'm asking myself the question. No, what's that fundamental right, Mullah? Kindly see
We
the
will answer at the end, not now.
Let's see the BNS. Mullah. Very simple, Mullah. The answer is here.
Yes.
Kindly see. Kindly see section 221 of the BNS.
No, let us first read the relief.
We'll see, Mullah, but since your lordship asked me this question, that they are wanting that nobody should interfere, the BNS has the answer.
Yes.
BNS obstructing a public servant in discharge of his public duties, functions. That's the answer.
Now let us read the prayer.
Now let's see. Page 40.
Page 46.
Let's see the prayer. Let's be clear, Mullah. Let's see what they are asking.
BNS.
Issue a writ of, I'm sorry, page 46.
Yes.
Issue a writ of mandamus directing the CBI to register FIRs. Here it is, but it says nothing. Has nothing to do with CBI. Please, here it is. Register, directing the CBI to register an FIR. How can ED ask for that? and investigate the entire incident in relation to obstruction of ED search conducted on 8/1/26? The answer is in BNS. At both the residential premises of one Patik Jain as well as the office of Indian PSC Consulting Private Limited, described in detail above, including the role of the respondent number 2 being the present Chief Minister for whom I am appearing, the Commissioner of Police Kolkata, the Director of General of West Bengal, and all persons acting in concert. So they, Manoj, thwarted the attempts of the ED
In this prayer, where is the scheme of PMLA coming into?
because they can't ask, ED can't ask the CBI to investigate. This is to be a separate predicate offence.
Well, it's not a predicate offence at all, my dear sir. It is not a
If you
predicate offence.
don't mind, unless there is a predicate offence under the code, now under BNS, ED cannot come into the picture. That is settled law.
ED
by
as
the
an
court
investigative
in several-
agency-
ED cannot file a writ petition for their fundamental right. They have no right to file a writ petition to have the CBI lodge an FIR.
Mr. Sibal will continue on Monday.
Yes,
Please,
that's
sir.
fine.
Please, sir.
Yes, that's fine. Yeah. It's miscellaneous, but it's miscellaneous.
You wanted to be, because
Tuesday.
My lords,
Tuesday would be better.
Wednesday, my lords, then
No, Wednesday would be, you see,
Thursday, whatever suits my lords.
No, Tuesday, Manoj.
any last working day became before long holiday.
No. We also want a holiday. We want you to work on the last working day. But Tuesday is fine. Tuesday.
No, judges,
Tuesday is
it
fine.
is, though this 23rd,
Tuesday is fine.
25th is Wednesday, but for
20
being the last working day of.
Tuesday.
I like Friday.
Tuesday, Lord, Tuesday.
Tuesday, Manoj.
Ah, Tuesday.
We are at item, the 25th is not the correct day. We are at item.
Third, Mr. Shyam Divan.
Tuesday, Lord, Tuesday.
Tuesday.
And
Yeah.
just one minute, Mr. Shyam Divan.
हाँ तो ये agenda.
Put up.
What
He is yet to conclude his arguments. Fourth Monday on Tuesday as part है. We'll take a Tuesday.
Tuesday, Lord. Grateful, grateful.
Grateful, my lords.
Okay.
Item 19, important matter.
Item 19, whatever date in all other matters, whatever date suits to learned advocates, they may take whatever they
In one matter, there is an interim relief till today, maybe extended.
Interim relief continued.
Take it, yeah, 19, item number 19, I will take it, yeah, Tuesday, Marad.
Tuesday, it will not happen.
It won't.
Don't take unnecessary. Knowing fully, all, you see, big guns are going. You think it will be
In the dark.
concluded?
In the dark.
And Mr. Banerjee, you know, I'm not commenting anything because
He is a double barrel gun, Manoj.
double barrel and there is one barrel outside also. If Mr. Banerjee starts about two of us, very difficult.
But item.
I am not so much.
No, it is on the lighter side.
But I am yes, I am not so much rowdy here, but I am really there.
You have to be louder here also.
No. My
They are not giving you chance.
my problem is this, Lord. Everyone misunderstands me. My voice is there.
No, we want to hear you also. We want to hear you also.
No, exactly.
Yes.
My great pleasure, my Lord.
Yes.
Thank you, Lord.
Lord, item, Lord, 15, the next item also, interim order is limited.
I know what they are going together. They are going together.
No, why interim order now? He is controlling state also. There is no problem. Mr. Solicitor.
You see, this is what Mr. Kapil Sibal is right, double barrel. It's a very loaded statement.
Mr. Solicitor.
It is very loaded statement
Mr.
that he is controlling it. It is the election commission which is.
I do not know.
Your statement is
I
loaded.
never control anything. But Lord, tomorrow, Lord, it would be reported that Mr. Banerjee considers that Mr. Mehta is going to rule the state.
No.
No, I am not concerned. I am not concerned. I don't.
Mr. Banerjee is saying that for a limited time you are controlling. Thereafter they will
Mr.
again.
Solicitor General, be happy with the 1 month.
That is what I am. That is what I am.
I am neither happy nor unhappy.
Nobody knows who will rule.
And
Whatever.
one thing, I just in a very lighter sense, I'm telling you. See, my lord, during last 5 or 7 years, at least 5 or 8 times, I have brought sweets and etc. from my constituency, but never Mr. Solicitor General has invited me for a coffee.
I plead guilty. I plead guilty.
That's right.
I have been the beneficiary of it.
Ask me whether I am incorrect or not.
No, I concede, I concede.
And sometimes I have been misunderstood by others. I mean, you are also understand why you are bringing sweets for me.
No, you bring sweets to, you see, from your state, we also get sweets.
Yes.
No, Mr. Banerjee always makes it a point to.
Your chief honorable.
I have a grievance because I never get any medals.
You get it in some other form.
In my constituency,
Yes.
Mr. Sibal would agree.
Yes.
My personal, at a personal level, not professional or any other level, I get many things before Mr. Sibal.
That is true, that is true.
Even from his residence.
but he has Mr.
We can't complain sitting here.
Yeah.
We may complain.
Well, Mr. Solicitor General, another one thing possibly your lordships do not know. In every occasion, whatever it may be, he sent wishes in Bengali and in a very nice writing.
Yes.
Yes. He never sends any in English.
He loves literature and
Yes.
all that.
Yes. That's
Mushaira, Sairi,
That's right. That's right.
poetry, like Mr. Sibal also.
Mr. Sabal, I am working with him since 1990.
He is versatile.
I am working with him since 1990. I first approved a matter in Supreme Court 82. I used to say to him, you are our, that time, this is 1990, you are our Maradona.
What?
Maradona.
Maradona. Diego Maradona.
Anywhere.
Not Diego Maradona.
Both, that footballer.
And that hand.
Yes.
Hand of God.
And my sides are two very senior counsels that time and famous. One side I was all the time. Whenever I used to come, either Mr. Simple or Mr. Chet.
And Mr. Divan is Pele.
Mr. Divan, I got it always other side.
Now you're saying.
Now we are in the same boat.
That's.
Anyway,
Sorry. Okay, nice. This is so nice.
Matter is.
I am regular.
which date you want?
First or second, madam?
So
That's a
second.
miscellaneous, dear lordship. The lordship will have to post a
First or
next
second, madam?
because that's only two.
I'm telling you first or second.
That's a miscellaneous.
Number one, it is miscellaneous, and number two, there may be some difficulty on first and second.
Lordship may have a week thereafter.
There may be some difficulty with this bench on those two.
But 10 was passed over. Unless the interim order may continue item. It was passed over. Item 10.
Let us finish one by one. What date you want?
Lordship may have it on.
One by one.
These are the two miscellaneous applications. You have to should not actually.
Lordship may have
We may post it on 8th April. Which item?
19.
Item 19.
Item 19. Item 19. 8th April.
19.
Yes.
105 regular by each person coming from Chandigarh. So have any actual date?
Actual date means?
Date.
Huh?
Actual date for each month.
Actual date.
और द टेकन अप नहीं हुआ है सिस्टम जनरेटेड डेट्स ऑटोमेटिकली हो जाएंगे
In all final hearing matters, regular hearing matters, system will generate a date. Automatically it will be posted whenever the Wednesday, Thursday.
I in fact appearing in person as is contact there.
You are in person.
Yes, my lord.
You have committed some misconduct.
I am advocate also, my lord.
Misconduct.
I can go down.
No. It is about some misconduct. It is about some misconduct.
Yes.
Not misconduct here.
That is the pertain Mr. Handed with me, my lord. My
What date you want?
any day, my lord.
Any day.
Date I can.
15th April कर देना है.
Please, my lord. 105 regular.
Item 10 में interim continue करो.
Item 20.
On other matters you can seek a date.
Then interim order to continue.
Yes.
So,
Right.